Morning to council. Not sure that you were here at the beginning of the first case. I indicated that Justice Irvin has potentially been exposed to COVID, so he will be wearing his mask today. Our next case is State versus Jones, and we'll hear from the appellant.
May it please the court, good morning. I'm Assistant Appellate Defender Nicholas Woomer-Dieters on behalf of the defendant, Tony Jones. I'd like to reserve 5 minutes for rebuttal, please. Nearly 50 years have passed since the United States Supreme Court held in Gagnon versus Scarpelli that defendants at probation revocation hearings are guaranteed due process. And further, that the minimum requirements of due process accorded such defendants include the right to confront and cross-examine adverse witnesses unless the hearing officer specifically finds good cause for not allowing confrontation. The General Assembly codified Gagnon in Section 15A 1345. The portion of that statute relevant here is subsection E, which provides that defendants at probation revocation hearings may confront and cross-examine adverse witnesses unless the court finds good cause for not allowing confrontation. The Court of Appeals held that Mr. Jones waived his right to confrontation for two reasons. First, because he failed to subpoena the state's witness against him, and second, because he did not ask the trial court to make a good cause finding that confrontation should not be allowed. This decision is not simply erroneous as a legal matter, it eviscerates the defendant's right to confrontation at probation violation hearings by making it practically impossible to properly assert the confrontation rights. And before I explain why, I'd like to review very quickly what happened in this case. So Mr. Jones was on probation. He's pulled over for speeding, and at least 3 officers approached his car. He's ordered to get out of the car, he complied, and one of the officers, a Detective Valdiviso, apparently noticed the butt of a pistol stuck between the cushion and the center console. Detective Valdiviso alerted another officer, Sergeant Norwood, to the gun, and Sergeant Norwood seized it. Mr. Jones was charged with possession of a firearm by a felon and carrying a concealed firearm. His counsel moved to suppress evidence from the stop. There was a suppression hearing, and only 2 people testified, Mr. Jones and Sergeant Norwood. The court denied the suppression motion, but when the charges went to a jury, there was a mistrial. And it's only after a mistrial is declared that Mr. Jones's probation officer filed violation reports alleging that he committed new offenses. They hold a probation revocation hearing in front of the same judge who presided over the trial proceedings and the suppression hearing. And to prove the commission of a new offense, the prosecutor moved to introduce the transcript of the suppression hearing that was held earlier, where Norwood testified as the state's sole witness. Now, the prosecutor argued that the judge had already heard Sergeant Norwood's testimony and that the transcript should be admitted for the purposes of judicial economy. But if the transcript wasn't admitted, the prosecutor said he was prepared to call Sergeant Norwood anyway. Defense counsel objected to admitting the transcript, but he didn't state any specific grounds for his objection. The judge admitted the transcript and revoked Mr. Jones's probation upon finding that he committed a new offense. On appeal, Mr. Jones argued that the trial court violated his right to confrontation by admitting the transcript over his objection. But the Court of Appeals held that he waived his confrontation rights for 2 reasons. The court's first rationale was that Mr. Jones failed to subpoena Sergeant Norwood, the state's witness against him. And it's hard to overstate how strange this reasoning is. A cornerstone of our legal tradition, if not the cornerstone, is that the moving party has the burden of proof and the burden of production. At a probation revocation hearing, the moving party, so to speak, is the state. The state has the burden of showing that the defendant violated conditions of its probation. The opinion below turns this fundamental principle on its head by holding that a defendant waives his right to confront adverse witnesses unless he calls those witnesses himself to testify against him, and the Court of Appeals shifted that burden at probation revocation hearings from the state to defendants. There's also a problem with the opinion in that it confuses the right to confrontation with the right to compulsory process. A defendant at a criminal trial has a Sixth Amendment right to confrontation. A defendant at a probation revocation hearing has a much weaker right to confrontation, which is derived from the Due Process Clause. It's weaker because it can be overridden when a court finds good cause not to allow confrontation. The difference between Sixth Amendment confrontation and the due process confrontation is one of degree and not scope. In other words, the only difference between them is that a defendant is not entitled to confrontation under due process if the court makes a good cause finding that confrontation should not be allowed. Now, as the brief discusses, in Melendez-Diaz, which is obviously a Sixth Amendment case, the U.S. Supreme Court warned against conflating the right to compulsory process with the right to confrontation. They're two distinct rights. Compulsory process gives defendants the right to subpoena their own witnesses. The right to confrontation puts the burden on the state to present its witnesses against the defendant. And the Court of Appeals confused this distinction. Furthermore, the opinion below makes it extraordinarily difficult, if not practically impossible, for a defendant to assert his confrontation rights. In this case, there are at least 3 different officers who approached Mr. Jones's car when he was stopped.
Mr. Wimmer-Dieters, just to make sure I'm following you, when you say the state is, the decision makes it extraordinary, I think your word was extraordinarily difficult to assert the right of confrontation. Are you making that argument solely in the context of the court's statements about the defendant's failure to subpoena Officer Norwood, or are you making a broader argument there?
I'm making a broader argument, Your Honor. I mean,
well, I don't want to get ahead of myself, but let's say hypothetically had the same thing, except that the defendant had said, Your Honor, I object the admission of this order, and the admission of this transcript violates my statutory right under GS 15A 1345E and Gagnon, I can't pronounce it correctly this morning for some reason. I mean, it's not that hard to say that. I don't think anybody would deny that that type of objection would be sufficient to raise the confrontation clause or the confrontation issue. Why? Help me, given the relative ease with which someone could do that, recognizing, having been there myself in the heat of trial, you don't always remember everything. But why does the opinion make it extraordinarily difficult to assert a confrontation right?
Yeah,
outside the context of the statements about subpoenaing
the statement about this, when I said that, it applied really to the subpoena issue.
Okay.
Now, with respect to the other issue, I mean, we can talk about that, and I intend
I assume we'll get to that in due time, but I just wanted to make sure I was following.
Right. I mean, there's no question that the attorney in this case could have, cited chapter and verse, right, Gagnon and 15A 1345E.
And didn't do that.
He did not do that. I mean, candidly, and I will get to that momentarily with the court's permission.
I'm just trying to make sure I'm following.
But going back to the subpoena issue, because again, these are the 2 grounds that the Court of Appeals holds are the basis for the waiver here. There are 3 different officers, at least, who approached this car. The defense had no way of knowing exactly how the prosecutor intended to prove the commission of a new offense here. But the state potentially could have introduced statements or reports from all 3 of these officers involved at the stop at the revocation hearing. So under the reasoning of the Court of Appeals, Mr. Jones would have had to subpoena all 3 of those officers to ensure that he did not waive his right to confrontation. Those officers would be sitting in court. He might not have to call them because, again, he doesn't know what the state how the state is planning on making its case, but we've got 3 officers who are off the streets, sitting in court, waiting to see if it's necessary for them to actually testify.
Didn't the state indicate that the officer was prepared to testify?
They did, Your Honor.
And is there any evidence or anything in the record that indicates that the trial court refused or otherwise prohibited the defendant from calling him?
The defendant did not call the officer. The defendant objected to the admission of the transcript, and the trial court overruled the objection and admitted the transcript into evidence.
And knowing that the officer was available and prepared to testify, the defendant did not indicate that he wished to confront the officer.
I think this kind of goes to the second issue, or the second rationale, Your Honor. But I think, the basis for the objection was clear from the context, because there's really nothing else, no other basis for the objection, right? The formal rules of evidence don't apply at probation hearings.
Well, to say that there's no basis for the objection other than confrontation, you have 2 places where there are objections. One, with the order, at least as I understood the transcript, it's the statement that counsel made there was the issue at the suppression hearing is different than the issue now.
That's correct.
And then the other time, there was no statement, it was just a pure general objection.
Yes, and I think that that's one of the problems that the Court of Appeals kind of conflated. They conflated the more specific objection to the admission of the order and the findings of fact to...
But at least with respect to the transcript, we have nothing other than a general objection.
That's a general objection, yes, Your Honor. So our contention is that from the context, there's only one thing it could have been, which is the long-recognized constitutional right to due process confrontation at probation revocation hearings, in addition to that's codified into the statute.
Why couldn't it have been, in essence, again, this transcript was developed at the suppression hearing, the issue in the suppression hearing is different than the issue of whether I'm guilty of these offenses, therefore I object on that basis. How's the trial court supposed to know that it's confrontation as compared to this whole set of factual documents goes to a different issue that's not before us, and on that ground I object?
I think the difference is, well, for one thing, I think that's a valid point, right? And I think it's important to, when assessing the prejudice here, it is the case that the scope of the former hearing, of the suppression hearing, it's a legal question.
Well, it may, with that respect, I don't think I disagree with you, but what I'm concerned about is, how is the trial court supposed to know that we have an objection based on confrontation grounds given what counsel said? Right.
I think that, again, if you read the transcript, it could be clearer.
I mean, I've done probation hearings before. I know how these go.
And there's also, let's go back to the language of the statute then. I think maybe we should, instead of, it might be appropriate to turn to the asking. There's a statute, this court is all but held between State versus Coltrane and State versus Morgan that 15A 1345E imposes a statutory mandate on the court.
Has it ever explicitly said that?
It did not explicitly say that, but what happened in Coltrane, first of all, in Coltrane, there was no objection from the defendant that the court had violated the defendant's confrontation rights. And this court,
I hate to monopolize your time, but you're going right to the series of questions I was going to ask, so don't just proceed there. If you look at Coltrane, in essence, it looks as if Ms. Coltrane was in court, said, you got some period of time to go get a job. She comes back, she's asked if she's, and the hearing consists of, you got a job? No, but, dash, which, at least the way I read transcripts, is an attempt to explain something that's cut off. And then the court reiterates, do you have a job? Answer, no. Boom, that's it. So Ms. Coltrane was clearly trying to give an explanation for why she didn't have a job at the time the trial court cut her off. That's a little different than a situation in which we have a counsel who lodges a general objection to one piece of evidence and a more specific objection based on the difference in the purpose for the suppression hearing as compared to the probation hearing.
Your Honor, I would acknowledge that, and I think my answer to that is to look at this court's more recent decision in State versus Morgan, where this court analyzed Coltrane. And in Morgan, this court made it clear that 15A 1345E imposes a statutory mandate. And here's what this court explained. Because no findings were made by the trial court that there is good cause for not allowing confrontation, and this is referring to the Coltrane case, that the trial court failed to comply with this, and this court called it a statutory requirement. Morgan went on to recognize...
Well, and that's pretty clear. I mean, the statute says if the issue, I mean, even the most restricted reading of the statute is if the issue of confrontation comes up, you've got to recognize the right unless those two findings are made. I mean, I don't think anybody disputes that, do they?
I think that's...
I mean, it seems to me Morgan is saying the question of confrontation, I mean, one reading of Morgan is if the question of confrontation comes up and you don't make these findings, it's error.
That's correct.
But to say that Morgan holds that 15A 1345E is a statutory mandate that the trial court must comply with in the absence of an objection, how do you get that out of Morgan?
Well, I think it calls it, if it's a statutory requirement that applies to the trial court, and what Morgan said more broadly is when a statute contains the language the court finds, the trial court cannot, the finding must actually be made, and the trial court, and by the trial court, and the finding can't simply be inferred from the record.
So your reading of 15A 1345 is that any time the trial court understands that a defendant may have a confrontation right, the trial court must intervene regardless of what anybody else may do and make those findings, or acting on its own motion, sustain an objection?
The theory is that there's a statutory mandate. That would be our principal theory of preservation here.
How does that argument square with the use of may in the statute?
The may in the...
in other words, the defendant, I mean, I've got it. Let me see if I can...
Right. The defendant may confront and cross-examine adverse witnesses. I mean, he's...
Doesn't that suggest that a defendant can waive the right to cross-examine?
Oh, I think...
If a defendant can waive a right to cross-examination, how is this a statutory mandate that compels the trial court, even in the absence of an objection, to either exclude evidence that arguably deals with affects confrontation, or make the two findings?
Well, I mean, the defendant doesn't have to cross-examine the state's witness. I think the point of the confrontation clause is that the state's required to bring the witnesses against the defendant to be subject to cross-examination as the defendant sees fit. Whether he chooses to exercise that right or not, I think that's what the statutory language that we're discussing.
So your argument is that once the defendant starts to cross-examine, the trial court has an independent obligation separate and apart from a specific objection to intervene if a confrontation issue may come up?
I think that I would say no, Your Honor. I think the question, I mean, and again here, I think there was an objection, unlike Coltrane. You know, there is a general objection here, and so that and so the question is, well, what's the basis of the objection? And our contention is that it was apparent from the context, and because we have the statute that again imposes what this court has called a statutory requirement on the court. to make a finding if it's not going to allow confrontation.
Counsel, let me make sure I understand something I think I heard you say. Did you indicate that the state is required to have all of their witnesses present at a probation violation hearing?
No, Your Honor, but let me back up there. If the state is presenting, let's say, reports or whatever, out-of-court information and bringing that into court, and it's of a testimonial nature, then the state should bring that witness to court, and if it does it, I mean, I guess the state has to call the witnesses that establish its case.
So the state, in reviewing a case, has a transcript of sworn testimony, and even though they're allowed to present hearsay testimony, letters, affidavits, any number of different forms of evidence, that the state, in preparing for their case, a summary proceeding, must have every witness present and prepared to testify, and have them present in court for a proceeding that is deemed summary.
I'm not saying, I mean, I guess the question would be, what are we talking about, every witness or just the witnesses that the prosecutor deems necessary to establish the violation?
But how would the state know that when, after the hearing, the defendant could go, you know, I really wanted to cross-examine that individual?
Well, I mean, I think that when for one thing, the defendant objected to the state's evidence here. And so it's not as if he's going back and say, I really would have liked to have cross-examined this individual. He objected to the admission of the transcript, and we have a statute which says that he's entitled to confront that witness against him.
What witness?
Any adverse witness, that's what the statute says.
But there was no witness called in the hearing, or at least on that point.
The witness would have been Sergeant Norwood.
And did he have the opportunity to cross-examine him previously?
He had the chance to cross-examine Sergeant Norwood in the context of a suppression hearing.
And what was the purpose of the motion to suppress?
To exclude evidence.
And what evidence specifically?
It was the evidence of the gun found in the car.
But just to follow up on what the statute provides, because it actually goes on to say, formal rules of evidence do not apply at the hearing, but the record or recollection of evidence or testimony introduced at the preliminary hearing on probation violation are inadmissible as evidence at the revocation hearing. Doesn't that lend some further support to the notion that while this is a due process right to confront as opposed to a Sixth Amendment right to confront, the statutory compilation seems to support the idea that witnesses should come in person, that you don't use transcripts from other proceedings?
Certainly, Your Honor. And again, it's always possible the defendant could waive the right to you can always, I guess, stipulate to the admission of reports and transcripts and so forth. But that right lies with the defendant, not with the state. It's not the defendant's burden to make the state's case for it. And
I'm sorry.
I was just going to ask you, at this particular probation hearing, when the defendant objected, if we adopted your interpretation of what the statute requires, what should the trial judge have done then?
I think the trial judge should have said, your motion is denied, to the prosecutor, the motion's denied, why don't you call Sergeant Norwood and we'll have a hearing. Apparently he was readily available, it wouldn't have been difficult. If you read these few pages, there's nothing to suggest that he's unavailable or difficult to call, or even that he's not out in the hallway. The prosecutor is completely willing to call Sergeant Norwood. It's just he's like, let's get out, let's move on with this.
Well, if he had not been there, say, if he had not been in the hall or in the building, how would, as a practical matter?
It would have been appropriate to continue the hearing. It would have been, I mean, and if there was some reason why, he was gone, I mean, we can speculate about why he'd be unavailable, but, upon a finding of good cause, Mr. Jones's right to confrontation would have been overridden, and the court could have admitted the transcript. So it wasn't as if, this doesn't impose a huge burden on our court system. In fact, I think the opposite position, or the position advocated by the Court of Appeals in this, creates this system where the defendant has to kind of preemptively, guess how the state intends to make its case, and then call those witnesses. And then it's not clear who actually does the direct examination. Is he supposed to directly examine the witnesses against him? So I think this creates a whole can of worms that just undermines the way we're handling probation revocation proceedings in the state. I want to just talk, well, actually, I'm going to reserve the remainder of my time.
Thank you, counsel. We'll hear from the appellee.
Good morning. My name is
If you need to
Christine.
hold the clock a second. If you need to lower the lectern, there's a thing right on the right there. There you go.
Thank you, sir. Good morning. My name is Christine Wright, and I represent the state in this case. The state respectfully requests the lower court's opinion and the trial court's judgment revoking defendant's probation be affirmed. The defendant did not preserve his right to confront for appellate review. At no time did the defendant request to cross-examine the state's witness, even when the state said that it was prepared to send those witnesses in if the state's request was denied by the trial court. Is it not true that in order to preserve this issue for appellate review, defendant must have presented to the trial court a timely request, objection, or motion stating specific grounds for the ruling the party desired the court to make? Here, a general objection is not good. As to the issue on appeal, a critical factor is, at the probation violation hearing, the defendant only objected on the basis of relevance to the issue of State's Exhibit 1, which was the order. Defendant did not object on the basis of the right to confrontation, which would be defendant's right to cross-examine Sergeant Norwood. The defendant objected and said, "Your Honor, but there is no evidence of guilt or innocence or any evidence or any omissions from Mr. Jones in this order." In addition, defendant's objection to State's Exhibit 2, which was the transcript from the motion to suppress hearing, was general, and its reason is not evaluated on the transcript. The defendant never requested to cross-examine the officer. The state clearly indicated that it was prepared to present those witnesses again if the court did not rule in the state's favor. So where is the evidence that the defendant objected on the ground of right to confront? According to defendant's brief, pages 20 and 21, and I quote, "If defense counsel made any arguments concerning the omission of the transcript of the prior suppression hearing, they were made during recess in the proceedings," unquote. Not on the record, but during recess. Defendant did not preserve his right to confront the officer.
So our rules do permit a general objection if to preserve error if the purpose of the objection is clear from the context, correct?
If it is clear.
Yes.
Yes.
And what then is the state's contention, particularly given that the prosecutor says, he can bring this witness, what is unclear about why there would be an objection to a transcript?
The objection that was made was for relevance, but here, before this court, in the Court of Appeals, the objection is set to be for confrontation.
But the objection on relevance was about the order, and the objection to the transcript, which the court then says, I'm going to admit this transcript over your objection. So the court must have had some understanding. In order to rule on the objection, they must have understood what the objection was. The court couldn't say, I'm going to introduce this transcript over your objection, even though I have no idea what your objection is, right? The court must have understood what the objection was to rule on it.
Yes,
And the court ruled on it and said, I'm going to introduce the transcript anyway.
yes, because the court found that I assumed that it was relevant, which would be opposite of what the defendant's objection was.
Well, in his brief, the defendant argues that under these circumstances, the only conceivable grounds for the defense to object to the admission of the transcript is that it deprived the defendant of his statutory and constitutional right to confront and cross-examine. That would have been obvious from the context. What do you say about that? Was there any other that would have been obvious from the context?
Well, when I view when one views the transcript, it's clear that the state, in making its motion to have the order and the transcript enter into evidence, as opposed to calling an officer, the grounds were clearly for judicial economy.
Well, doesn't the Court of Appeals also say on page 8 of the slip opinion that there was an argument made by the probationer that the transcript was being introduced for the purpose of showing that he had committed an additional crime while he was on probation? Or is that erroneous by the Court of Appeals to cite that?
Yes, it was entered for that purpose as well.
So if that's the case, then there was indeed some other area of objection that was not necessarily clear at the time, aside from the right of confrontation, if in fact there was something raised about the transcript being produced for the purpose of showing an additional crime. Is that right?
Yes.
I mean,
Well, let me-
just to follow up on Justice Morgan's question, I mean, I'm the one that you can't see their mouth moving, isn't it? I mean, the truth is, we just don't know what the basis for that objection was to the transcript because it's a general objection, right?
But I think we do know that the state argument was clearer than the defendant's objection. And to back that up, even when the defendant requested for defendant's exhibit number 1 to be entered into evidence as opposed to having defendant's witness come to court, the defendant said, and I quote, "For judicial economy, we are trying to get this affidavit published to the court." So with that being said, I think it's more evidence in the state's favor as to why the judge ruled.
So isn't saying judicial economy sort of shorthand for saying, so we don't take the time to put the witness on the stand and have the defendant cross-examine him, basically? I mean, what else could that be referring to?
Yeah, sure. In a probation violation hearing, contrary to the defendant's brief, Morrissey is controlling in this case and not Crawford. In Morrissey versus Brewer, the United States Supreme Court held, which applies to both parole and probation violations, and I quote, "We emphasize there is no thought to equate this second stage of parole revocation to a criminal prosecution in any sense. It is a narrow inquiry. The process should be flexible enough to consider evidence, including letters, affidavits, and other materials that would be not admissible in an adversary criminal trial, unquote. In addition, Morrissey further states that at a probation hearing, the Sixth Amendment rights of the defendant are not involved. Constitutional rights and parolee probationers are protected through 14th Amendment due process, which does not call for a full panoply of rights due to a defendant in a criminal proceeding. The right to confrontation is indeed very distinct from Sixth Amendment right to confrontation applicable to criminal prosecutions.
Even though that may be the case, doesn't the existence of the statute that says that he has a right to cross-examine unless there's good cause, in the face of the prosecutor's assertion of judicial economy, which could easily mean, let's not bother with that, putting him on the stand stuff, shouldn't that have tipped off the trial court that, oh, wait a minute, are we skipping past the right to cross-examine here?
I do believe that the trial court should have been clearer, but even with the case as it stands, I think there is sufficient competent evidence in the record that would support the trial court's decision.
What did the trial court do that indicated that he was satisfying the requirements of the statute?
The statute requires a finding, a good cause finding, when the court rules that other evidence, for instance, a transcript, would be admitted. There is, again, notations in the transcript for the good cause reason, which, from the state's interpretation, would have been judicial economy. The Court of Appeals did not outright say that, and I certainly believe that the Court of Appeals, if this could have been clearer, but the fact that it's not totally clear, I believe that it could be rectified, but it can be gleaned from the record.
What's the responsibility of a probationer to make sure that the record is clear then? Is there an assertive right on the part of a probationer to make it clear that he or she is asserting the rights of confrontation here, and what should that be if you agree that indeed there is some assertive affirmative right of a probationer to do so?
Yes, sir. In the defendant's brief, and I'm going to answer that in a roundabout way. In the defendant's brief, there's a quote from James Markham from his writings entitled Confrontation at Probation Violation Hearings, North Carolina, March 2011. And the defendant quotes in the brief on page, I believe it's 27, while less robust than Sixth Amendment confrontation, due process confrontation is not so flexible as to be meaningless, unquote. But if you continue reading James Markham's writings concerning confrontation at probation violations, and I'm going to quote what he says. He says, and finally for the probationers, it seems the best advice on this front may be that if you want to confront an adverse witness, be sure to bring it up at the probation violation hearing. Don't raise it for the first time on appeal. And then Jamie Markham cites State v. Duncan, and And in that case, and he quotes, "Nowhere in the record does it appear that the defendant asked to cross-examine any witness for the state, and particularly the state probation officer, and was refused," unquote. So the court here did not deprive the defendant of his statutory and due process right to cross-examine Sergeant Norwood. Nowhere in the record does it say that the defendant asked to cross-examine any witness for the state, particularly Officer Norwood, and was refused. We should not be concerned with what the defendant is saying now. We should be concerned about what he said on the record. Defendant is swapping horses between courts in order to get a better mount. Defendant is asking for 2 bites of the apple when he is only entitled to 1. The trial court did not err when it admitted State's Exhibit 2. Here the judge clearly stated why he admitted State's Exhibits 1 and 2 in the sense that it came following a narrative about judicial economy.
Well, so let me just ask you a little bit about this, your argument that judicial economy is good cause under the statute to deny a defendant the right to cross-examine witnesses at a probation hearing. Doesn't that essentially eliminate the right altogether? I mean, it's always going to be faster to not have to call a witness in and have them get up on the stand and testify.
But in this case, we have the same judge that heard the motion to suppress hearing, the same judge that heard the probation violation. And this same judge in this September 14 transcript, pages 19 through 12, said there may be additional evidence to be presented. He left it open for the defendant to call witnesses. There wasn't a transfer of burden of proof. What this court interpreted was the defendant never requested to cross-examine the officer, but he may call any adverse witnesses, subpoena any witness that he wanted to, but that same defendant had the opportunity to open his mouth in court and say, hey, I would like to cross-examine Officer Norwood, but he never said that at any given time. It is not in the record. But what is in the defendant's brief is some conversation that happened during recess.
Right, well, he did object to the introduction of the transcript. And what I'm asking about is your contention that the statute was complied with because the judge found good cause, and that cause was judicial economy. And my question is, if we agree with that, aren't we essentially writing the statute out of existence?
I'm sorry, the last part, are we?
Aren't we essentially writing the statute out of existence? We're negating the statute.
No, we're not. I don't believe we are. What we're doing is following Morrissey v. Brewer, which allows for affidavits, transcripts, and other evidence to come in during probation violation hearings. We're not talking about criminal proceedings, the Sixth Amendment.
Right, well, so you're not contending, are you, that the right to cross-examine witnesses is not an element of due process?
I'm not writing that out, no.
Okay. So the statute contemplates that a defendant may cross-examine. Yes, it says that the rules of evidence are relaxed, and yes, affidavits can come in, but it also says that even in a probation hearing, the defendant has the right to cross-examine, may cross-examine witnesses against him.
Right.
Unless there's good cause.
Yes.
Right.
In addition to that, at least I understand over here, your argument in your brief that effectively you've got an implied finding of good cause, how can that be squared with the language in State versus Morgan that says, quote, such a finding cannot simply be inferred from the record? I mean, aren't you asking us to, at least in that part of your brief, aren't you asking us to infer a good cause finding from the record?
Yes, sir.
Well,
That
if
is
you are,
correct.
how can we square that with Morgan?
Yeah, it is problematic. It is.
Okay, thank you.
Ms. Wright, switching gears just a little bit, and your learned opponent there may correct me if I misunderstood something, but in response to Justice Berger's questions about who needs to be available, what witnesses need to be available, at least what I heard in his answer was that I don't know that every witness had to be made available, but a very large number, and you talk about that under the case that allows for transcripts and reports and that sort of thing, and you mentioned judicial economy. Do you agree that you need to have those witnesses in the wings, or how do you see that should be applied? What is the rule there? And again, if I've misunderstood his position, I'm sure he'll correct me here in a few minutes.
Yeah, just from real life, from a practical standpoint, I'm envisioning the state standing before the court, making the motion. And once if the motion is denied, it's the state's responsibility to call those witnesses. If those witnesses aren't called, then it's to the state's detriment. Sometimes, but in this case, they were there. But in the case if they weren't there, it would have been the state's responsibility to have those witnesses present. And if the probationer requested to know which witnesses would be called, the state would have communicated that to the defendant in the natural flow of how probation violation hearings normally go. It's normally not a mystery, but if the state failed to come through, so to speak, it would have been to the state's detriment, and the defendant would have had a good case of challenging based on the statute.
And then just to follow up, so what I'm hearing is that when this document, of whatever it might be, whatever nature is offered up, then it would be incumbent on the defendant to object and state why. And then at that point, there would be the necessity to provide that or not have the document brought into evidence. Is that,
Yes.
Do I have that about right?
Yes.
Thank you.
The defendant cannot establish prejudice as there was no reasonable probability that, but for the asserted error, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. There is enough competent evidence in the record to support the trial court's finding, and these findings are absent a showing of manifest abuse of discretion. The state respectfully requests that lower court's opinion and the trial court's judgment revoking defendant's probation should be affirmed.
Thank you, counsel. Rebuttal.
May it please the court. The state mentioned the flexibility at probation revocation hearings that's discussed in Morrissey versus Brewer, and that's absolutely correct. And I think it's important to emphasize that probation revocation hearings are quite flexible, but they're not, the state does not have carte blanche to put on any evidence it wants. The standard here, or the relevant principle here, is that under due process confrontation, you have a substantially weaker right to confrontation. The reason is because once the court makes a finding that there's good cause to override the defendant's right to confrontation, then the defendant doesn't have a right anymore.
Counsel, I'm sorry, go ahead.
I would say at that point, the state is free to, admit reports and transcripts and so forth. And I think that the statute recognizes that that's probably going to happen in a lot of cases. The difference is that in this particular case, where we have the officer readily available to testify, apparently, there isn't any good cause.
Counsel, if I could at this point, your friend on the other side brought up the case of State versus Duncan, and Mr. Markham's comment on that case in his article that is cited in your brief. You also cited State versus Duncan in your brief under the section, at a probation violation hearing, defendant has a due process and statutory right to cross-examine adverse witnesses unless court finds good cause. Is State versus Duncan still good law?
I mean, in the sense that, I mean, I think, yeah, the principle that, that a defendant has the right to, you know, that if the court makes a good cause finding, that the defendant loses his right to confrontation. I think that's...
Well, doesn't Mr. Markham in his article go beyond that, though, and basically cite the factual determinations in State versus Duncan? Shouldn't Duncan guide our decision in this case?
Your Honor, in all candor, I'm forgetting the factual, the specific facts that were at issue in State versus Duncan right now. It's escaping me. I think what, in our view, the governing cases are Coltrane and Morgan in terms of the preservation issue. And I think that, and of course, Gagnon versus Scarpelli and Morrissey versus Brewer. Justice Berenger mentioned that, and I think I may have misspoken when I was speaking to Justice Berger earlier, about calling every witness. And I just want to make clear that, you know, the state at these hearings has the option to either call whatever witnesses the prosecutor sees fit to establish that a probation violation occurred, or to make a showing of good cause and have the court agree that there's good cause and therefore submit instead of a live witness, transcripts, reports, and so forth. I think the question here is not whether counsel's objection was the best objection that he could have made. The question is whether counsel's objection to the admission of this transcript was good enough. And our contention is that, given the context where we have a statute that this court has ruled imposes a statutory requirement on the court, and given the fact that there is really no other basis for the objection under the circumstances, that this court can infer an intent to lodge an objection based on the confrontation clause. This has been the law of the state. I'm sorry, it's been constitutional law for nearly half a century. It's been codified into a statute which has mandatory language, and so for those reasons, we ask that this court reverse the decision below. Thank you very much.
Thank you, counsel. Thank you to both. Mr. Clark.